In many countries, the criminal law is still used to protect reputation. Many defamation laws originated, often centuries ago, as part of the criminal law of the states. This suggests that there is perceived to be a public interest in the state initiating criminal prosecutions against journalists or others, something that goes beyond the right of the individual to protect his or her reputation. It is closely related to the concept of sedition, or seditious libel in the common law, which penalises speech and other expression that is critical of the government or of the state. Yet increasingly the whole notion of criminal defamation is seen as antiquated and anachronistic. Criminal defamation laws represent a potentially serious threat to freedom of expression because of the very sanctions that accompany a conviction. A number of international courts and other bodies have condemned the threat of custodial sanctions, both specifically for defamatory statements and more generally for the peaceful expression of views. The UN Special Rapporteur on the right to freedom of expression is among a number of international free speech watchdogs that have been arguing that criminal defamation laws should be repealed in favour of civil laws, as the latter are able to provide sufficient protection for reputations. The UN Human Rights Committee has recommended that states should consider the decriminalisation of defamation and has clearly stated that imprisonment is never an appropriate penalty. The Parliamentary Assembly of the Council of Europe has made a similar recommendation, describing the threat of criminal prosecution as a sword of Damocles hanging over the heads of journalists. While the European Court of Human Rights has not ruled out the possibility of criminal defamation charges, it has stated that there are a number of very strict protections that should apply when a criminal defamation law is used. If defamation is part of the criminal law, the criminal standard of proof that guilt is established beyond a reasonable doubt should be fully satisfied. Convictions for criminal defamation should only be secured when the allegedly defamatory statements are false and when the mental element of the crime has been satisfied. That is, when they are made with the knowledge that the statements were false, or with reckless disregard as to whether they were true or false. Penalties should not include imprisonment, nor should they entail any other suspension of the right to freedom of expression or the right to practice journalism. Finally, states should not resort to criminal law when a civil law alternative is readily available. The court has made this clear in several cases, for example the recent case of Amorim Giestas versus Portugal.